Let us begin then with introductions. And if I introduce, please, David Elvin QC first. He practices in planning, environmental, public and property law. He's appeared in many of the leading cases in those areas. He's the general editor of the Planning Encyclopedia, deputy judge of the High Court, including sitting in the Planning Court, and a recorder in the Crown Court. He's also been a parliamentary boundary commissioner for England for some 10 years. He has experience of many cases heard remotely in court during the current pandemic, which of course is relevant to his talk. He's a bencher of the Middle Temple and a member of the Bar of Northern Ireland. His talk, as I say, is going to be on COVID-19 and the planning court. Sasha White practices in planning and environmental law. He's a leading inquiry practitioner with many notable cases behind him. He was nominated as Planning Barrister of the Year by the Legal 500 in 2020 and is the head of the planning group at Landmark Chambers. Sasha's talk will be on bias and predetermination in planning law. Kate Olley is a planning and judicial review specialist. She's just finished acting with Chris Kokoski QC for the applicant in the UK Holocaust Memorial Inquiry and is currently in the middle of a large planning appeal in Hong Kong concerning the wetland area on the border between Hong Kong and China. Kate's talk is on the implications of the Environment Bill for High Court legal challenges. And finally, James Maurici QC. He was called in 1996 Queen's Counsel. In 2013, he practices in planning, environmental law and public law. He was the chair of the planning steering group at Landmark Chambers from 2017 to this year, and in October of this year, he was elected as a member of the board of the Compulsory Purchase Association. He's been in many high-profile court cases, and recent ones include the Compton case dealing with the challenge to Guildford Local Plan, Spurrier and Plan B cases against the Secretary of State for Transport involving challenges to the airport's NPS, the Shirley case dealing with the interpretation of the Air Quality Directive, and the RSPB case, which involved a challenge to the revised Aarhus costs rules. James's talk will be on the matters of practice and procedure and updating the position. So without more, can I pass on then to David for his talk?
I've already flipped past the first page, but let's not worry about that. The first page is simply the Lord Chief Justice has just issued his annual report as at the beginning of November, and he deals there with the struggle which the courts have had, dealt with rather successfully, I may say, in many respects, with the pandemic and the need to have remote hearings in many cases. And the point he makes, which is borne out by experience, as I'm sure many of you will already be familiar with, is that there isn't one size fits all. And whilst remote hearings have proved very valuable for keeping the wheels on the system while we're in lockdown or close to lockdown, there are still some hearings that may require to be in person, that there are disadvantages to remote hearings. To some, they're much more tiring. There can be technical difficulties, he says, having been muted for the first minute of his speech, but that these are offset by the benefits. And certainly experience seems to suggest that it can work very effectively, particularly in judicial review and particularly in the area of concern to ourselves, which is remote court hearings for planning challenges, where we don't have witnesses, where people can attend without being part of the process but still watch the proceedings, and advocates can still get out their submissions and get the judge to understand what their case is without too much difficulty. I'll share some experiences with you in a moment. I've done about 6 weeks of sitting myself as a deputy during the last 9 months of lockdown, so I've dealt with quite a few problems. I've also appeared several times in remote hearings, including one which I shall give you a little more information about in a moment. There is a lot of guidance now available. You've seen on the screen the compendium, which is generally available across all jurisdictions on the judiciary's website. It includes most recently the revised guidance on wearing face masks in courts for when there needs to be actual attendance. And certainly there are some planning cases I'm aware, where the judges have requested attendance in court, because of course in most planning cases there's no need for many people to be in court, and social distancing and the like is perfectly feasible. There may be reasons why you don't want to be in court, depending on particularly which tier you now come into and depending on issues of vulnerability. But nonetheless, it is perfectly achievable where it's necessary. You'll be aware of Practice Direction 51Y on video and audio hearings, which came out fairly rapidly. The civil justice system has reacted very quickly in lockdown in order to keep proceedings going. And the first guidance on remote hearings came out on the 26th of March and has been updated since. There's the reference. And the specific guidance to video and telephone hearings. At the moment, the court is still operating on multiple platforms. You may find yourself on the court's own system, which not too many people seem to be familiar with in the planning court, or Skype for Business, or Teams, and you just have to see which version the judge is using in order to take part. There's specific administrative court guidance, important to read it for reasons I'll come on to in a moment. Everything, as you will know, is to be filed electronically. Bundles are electronic, proceedings are electronic. Simple reason, of course, is the court offices are closed and all of the administrative court officials are working from home. Now, importantly, Mr. Justice Holgate, the planning liaison judge, issued to those who could disseminate the information, that is to myself as editor of the Planning Encyclopedia, to the JPL, to the Law Society, and to the Planning Bar Association, a series of points of informal guidance. And he gave what he called top tips, which I had published straight away in the Planning Encyclopedia April Bulletin. And they basically are points to give significant weight to when you are preparing a case for the planning court. Do not take up unnecessary time in the judge's reading with unnecessary papers. The courts, I know you'll say, the courts bang on about this all the time, but it is absolutely true. Where you've got remote hearings and electronic bundles, the court does not need to be burdened down with thousands of pages of paper. And it's something which the planning liaison judge is very keen to point out. And you see those those 2 points that he makes there. He also makes the point that if you are going to compromise your claim, then by all means withdraw as quickly as possible. Don't fill the lists unnecessarily, and don't take more issues than you need. Don't run those points 8, 9 and 10 that you know are just points that would be nice to have, but you're never going to get them really. So focus on the points that really matter. Bundles have to be absolutely well chosen. Certainly in the case I did recently in front of Mr. Justice Holgate with multiple parties, he'd requested a core bundle, and the core bundle came in longer than the bundle he'd asked for in the first place. The core bundle initially came in at something like 800 pages, which was not what he'd had in mind at all. He used the words micro bundle, which goes back to a case that he and I did in front of the then Mr. Justice Carnworth many years ago, which really is a pared down what you absolutely need to understand the decision and the decision-making process. You don't need court orders. You don't need the grant of permission. I think the judge can be expected to know that permission's being granted in a substantive JR because the judge is actually hearing it. But it requires a lot of common sense, and trying to get people to agree sometimes as to what the judge actually needs is remarkably difficult. And from the judge's point of view, speaking from experience of 6 weeks of electronic bundles, the last thing the court needs is to be overwhelmed with multiple papers simply because it's easy to attach them all electronically. Bundles of authorities similarly, don't repeat what's in the ICLR casebook. That's the blue book, which with the forwarding by Mr. Justice Holgate, you don't need to repeat those, and you don't need to endlessly multiply documents. And a point that I found in a particular case, make sure that the electronic bundles are well paginated, hyperlinked and the like. This all sounds tedious, common sense, but you'd be astonished how many times it wasn't observed. In one case, which I'll come on to in a moment, not only was the core bundle over 1,000 pages, but all the bookmarks and the hyperlinks took you to exactly the same page. which was rather difficult to use in terms of pre-reading. That is the case of Thurlow Lodge, which set out and endorsed respectfully Mr. Justice Holgate's informal guidance. I have to confess that that was my decision, and I was rather hoping that James Maurici was going to be doing this, but apparently I had to do this myself, and he wasn't going to take over this to save me the embarrassment of referring to one of my own judgments. However, this is the case where, as I mentioned, the hyperlinks and the bookmarks did not work. I'd been given a day to read several lengthy bundles and bundles of authorities, and it was just impossible. I actually had to go back to the parties and say, you will have to redo the electronic bundle because I just can't deal with it. I don't have time. You don't have time when you've got pre-reading to re-link the bookmarks and all those sort of things, so you can find out. You've only got enough time to read the key documents and to mark up those pages electronically that you do have time to read. You don't have the time to do the work that the claimant ought to be doing in the first place. I've already mentioned the COVID-19 guidance, and I referred to that in terms of the advice for compiling the bundles. Since then, the COVID-19 guidance has been updated. It tended to be limited to immediate and urgent cases. It's now been expanded to include non-urgent cases, and you'll see there those paragraphs setting out requirements for core bundles, further bundles, file size restriction, and making sure that the documents do meet minimum requirements and do not overburden the court with material that it doesn't need and will get in the way of its understanding your case. But ultimately, at the end of the day, you're trying to persuade the court of the validity of your grounds or your defence. The last thing the court needs to do, and the last thing you need to do for your client, is to put in documents that get in the way of the judge understanding your case, because the judge is spending too much time having to sort out which documents are necessary and which are not necessary. So please bear that in mind, because it is a very real issue, particularly since if you get a list of cases, say permission renewals, you've got a whole series of electronic bundles to get through on screen, and it can be a little more wearing than looking through papers. Finally, authorities, as I've already mentioned, the ICLR leading planning cases is there, so you don't have to cite endlessly cases such as Tesco and Dundee, South Bucks number 2, and all the well-known authorities. And there are a number of judges in the planning court, including Mr. Justice Holgate, who want the reported versions of the cases with head notes, not simply the neutral case citation transcript. It's also a word of warning before I finish. It's also necessary to bear in mind, and most judges will make this clear, and the guidance certainly makes it clear, proceedings being heard remotely are as much court proceedings as if you were sitting in the courtroom. The normal civilities and procedures must be observed, and it's effectively as if you are still in the courtroom. Even if you're sitting at home in your kitchen with the kettle going in the background, you are still in court. The rules of contempt of court still apply. And indeed, that includes the rule that it is a contempt to record court proceedings. The court will tell you that it records the proceedings itself, as it always does in judicial review cases, and fully records proceedings where there is where it's a permission application. There's usually a warning to the parties that you are not to record unless you have the permission of the judge. The case I've just mentioned relating to Mr. Justice Holgate and the core bundle, he ended up summoning the BBC to court the day after the case finished. It was a 2-day case, and the BBC had broadcast a recording of part of the hearing which someone had made in breach of the normal rules about recording and broadcasting court proceedings without the permission of the court. Having had a preliminary hearing, I note the judge has just transferred a determination of the contempt proceedings against the BBC to Mr. Justice Warby, which proceeds on the basis, I assume, that there is something there at least to investigate, because an independent judge, not the judge in front of whom the contempt is alleged to have taken place should determine the matter. So please bear in mind not only the need to assist the court and to assist your client by putting your best foot forward in terms of the documents and not overburdening the court, but that it is also to be treated as ordinary court proceedings and the normal rules apply. Thank you very much. I'm now going to hand over to Sasha to deal with the issue of bias.
Thank you very much. Thank you. Great. Good afternoon. Thank you very much, David, for that. That was incredibly insightful and informative. I'm going to talk about bias and predetermination in planning law, and obviously how the role it plays in the High Court, and obviously my kind of template and my touching base is Westferry. I represented Tower Hamlets with Guion Lewis in the Westferry litigation, which we will come on to deal with. And obviously in that case, it dealt with at great length the question of apparent bias. So what we're dealing with, of course, are two elements of potential judicial review: bias and predetermination, which of course are closely related and even have a degree of overlapping. And of course, they both fall within the general heading of fairness and questions of fairness in decision making. Bias, of course, relates to showing, or in the case of alleged bias, or being perceived to show by inclination or prejudice for or against one party in an interest in a way that is unfair. Predetermination obviously relates to decision makers' ability to effectively reach a decision based on a closed mind prior to when they actually, when they come to make the decision, but based on having previously reached a view. Actual bias, in terms of bias, of course, there are two classes and categories in law that the law recognises. Actual bias, which of course for evidential reasons is very difficult to prove, so the cases are extremely rare, and in a sense it's pretty much redundant because it's unnecessary to go that far, because you have effectively the apparent bias category, which would be sufficient, as we saw in Westferry. It immediately would disqualify a decision maker from continuing with a decision, and it would be conclusive as a vitiating factor if proven in relation to a decision. Apparent bias, the key test is as set out in the McGill case against Porter in 2002, and it would a fair-minded and informed observer, having considered the facts, conclude that there was a real possibility of bias. So remember, fair-minded, informed, considering the facts, conclude a real possibility of bias. And the examples of that apparent bias were effectively, there are three examples I wanted to bring to your attention. A case involving Harlow District Council, where the planning committee chairman voting in favour of the grant of a planning permission had discussions with the developer about how to facilitate the scheme. That was obviously quashed. Secondly, a case involving Enfield, voting in favour of a scheme after expressing support for the proposal on another committee. And lastly, a case from Wales. It was possible to express legitimate predisposition towards an outcome without this amounting to apparent bias. In that case, the Assembly Chair of Wales had, before the decision, said, I'm going to go with the inspector. But in that case, it was decided it didn't amount. That expression of view did not amount to apparent bias. Other example, Freemasons. Obviously, there have been allegations and concerns about Freemasons, but in the case of Port Regis School, in the prep school in North Dorset, there a Freemason wasn't necessarily precluded on a planning committee from voting if another Freemason had an interest in the outcome. And that, again, that case shows the importance of applying the McGill test by reference to the informed observer, i.e. having considered the facts. And the court took the view that many people might assume that Freemasons are bound to assist each other, but evidence is that Freemasonry is underpinned by impartiality and fairness. In the case of Lewis and Redcar Cleveland Borough Council, it remains the leading case on predetermination. in planning, and as some of you will know, the government did change the law some years ago to make predetermination a more difficult hurdle to attain in judicial review. Voting councillors had previously made strong statements in favour of the development that was before them. The High Court found apparent bias and predetermination mainly because the meeting to vote to grant permission was held during an election period, contrary to local authority guidance. But the High Court did find that the development had become a party political issue during the election campaign, and therefore they did come to the view that an informed observer would consider that there was a real possibility of bias. The Court of Appeal came to look at this decision and took a more pragmatic approach, and they took the view that the local authority decision-making was different from, say, a court or a quasi-judicial decision-making process such as a planning inspector, and therefore there was in litigation only limited role for apparent bias and predetermination arguments. Elected members would, and Pill LJ, who many of you will know, he made many decisions on planning matters, he concluded that elected members would be entitled, indeed expected, to have and to have expressed views on planning views. And as Rick's LJ said, there can be no pretense that such democratically accountable decision makers are intended to be independent and impartial, just as if they were judges or quasi-judges. And therefore something more in law, something more is required that goes to the appearance of a predetermined closed mind. So let me then move on and talk a bit about Westferry, because obviously it is the seminal decision on alleged bias for various reasons. First, as you can see, it was a very, very significant scheme in Tower Hamlets of 1,500 units. There was a 3-week public inquiry in August 2019 when I represented the Tower Hamlets, the LPA, who were objecting. I think there were 6 reasons of refusal. The inspector, David Prentice, having heard the evidence, the GLA were also involved. So it was basically the GLA and Tower Hamlets lined up to oppose the grant of consent. The appellant obviously was seeking consent. The inspector did recommend refusal of planning permission and took the view that there are multiple breaches of the development plan, particularly including heritage impacts. The World Heritage site that many of you will be familiar with of Greenwich is just across the river and has great views of the site. The Secretary of State, who is the current Secretary of State, disagreed with his decision in January of this year. Seems like a lifetime ago, but it was actually, and the decision was issued 1 day before the council were due to approve their new SIL charging schedule, which would take effect in 3 days. The SIL charging schedule, not unsurprisingly, would have had a very substantial hit on the scheme at Westferry, and the developer was looking at an increased payment of approximately £40 million if planning permission was granted after that. So effectively, the consequence in practical terms of the decision coming out when it did was that the developer was saved the £40 million SIL liability. In our pre-action letter, we wrote to the Secretary of State, and it just, one lesson it does say, be careful about kind of games that people enter into, because the council, we asked the Secretary of State to explain the timing. The Secretary of State responded by admitting that the decision expedited, but we were accused of being on a fishing exercise. I always have remembered that. As you can imagine, it's been implanted on my psyche, that original response. That we did go forward with the issuing of the claim. We alleged that a fair-minded and informed observer, in the light of the McGill test, would conclude there was a real possibility of bias in favour of the developer with the timing of the release of that decision and the consequences for the developer. As most of you will know, the Secretary of State conceded to judgment soon after the claim was issued. The Planning Court did approve the consent order. Mr. Justice Holgate, as David has mentioned, agreed between the parties the consent order, and it remitted the appeal back to a different minister where it now resides. We did seek, it's important in this case, we did seek specific disclosure for various internal communications, and the concession at the time it was reached by the Secretary of State avoided further disclosure. And I have no reason to believe this, but I've always felt that one of the major driving forces into making the consent order and offering the consent order at that stage was to preclude the need to disclose anything further in accordance with our request. But of course, as the matter gained political traction and investigation, the Secretary of State was ultimately in July required to release the documentation as a result of parliamentary and political pressure. So the successful tactics from the claimant's point of view that I wanted to identify, we did have our ground. We only alleged one ground. There was obviously a lot of a debate about what else, but we took the view that only apparent bias should be contended, and therefore there was no room for the Secretary of State to concede on other less problematical political contentious grounds than the alleged bias. The Council also, we sent a pre-action request for disclosure and compliance with the duty and the candour, in knowledge that the Secretary of State does not engage in standard pre-action correspondence for Section 288 challenges, and we didn't set out the grounds, we just focused on the disclosure request. And the Secretary of State at that stage did resist any disclosure, contrary to the duty of candour at pre-action stage. Therefore, the Council were able to rely on the Secretary of State's resistance to disclosure as part of the narrative in the statement of claim of its case on apparent bias. The disclosure request, I just felt it would be helpful for you to see it if any of you are involved in such litigation as claimants. This is obviously what we sought, and we sought, as you can see, it was pretty broad and pretty universal. Memoranda, file notes, text messaging, or other records of communication. And of course, as subsequently was released in July, some of the most seminal material came from WhatsApp messages between the Secretary of State and the developer. And then again, we were also pretty general as to who we directed that to, the Secretary of State himself and or any of his team or representatives. And it's very interesting to look at the 135 pages of disclosure that went before Parliament in July. So then I just wanted to go to the other side, just to assist those who have got to defend such claims as a defendant. And in terms of apparent bias, it is of note that no significant weight is generally given in the High Court to witness statements by the decision maker claiming that the decision was made with an open mind. It obviously contravenes the kind of post justification. And in terms of evidence, what is required are the facts to inform the informed observer would take into account that relate to the matter that's being litigated. Obviously, the need to explain the decision-making structures and organisation, and evidence of the decision-maker completing training in relation to apparent bias and predetermination is probably of assistance as well in any such response to such litigation. So I hope that's a reasonably helpful run through of predetermination and bias. And I will hand over to Kate.
Thank you, Sasha. Right, I'll give an overview of the Environment Bill to set the context. So it's a bill in 8 parts, 139 sections and 20 schedules. And according to its long title, it makes provision for targets, plans and policies for improving the natural environment, for statements and reports about environmental protection, for the Office for Environmental Protection, about waste and resource efficiency, air quality, for the recall of products that fail to meet environmental standards, about water, about nature and biodiversity, for conservation covenants. Just like to mention that Pinsent Masons have done a very good briefing note on biodiversity gain in planning and conservation covenants, which you might want to have a look at, about the regulation of chemicals and for connected purposes. So a very large brief indeed. I'll focus on part 1 for the purposes of today's presentation, which is in 3 chapters. So a word about the targets. They'll be set by regulations and will be long term, meaning at least 15 years, and in relation to the natural environment or people's enjoyment of it. A long-term target must be set in respect of at least one matter in each priority area, and that means air quality, water, biodiversity, and resource efficiency and waste reduction, so 4 things. The targets will have to specify a standard to be achieved which is capable of being objectively measured, and also the date by which it is to be achieved. And before making regulations which set or amend a target, the Secretary of State must be satisfied that the target or amended target can be met. So lots of questions to be answered there. Target could by regulations be lowered or revoked, but only if the Secretary of State is satisfied that meeting the existing target would have no significant benefit compared with not meeting it or meeting a lower target, or whether because of changes in circumstances since the existing target was set or amended, the economic, social, environmental, or other costs of meeting it will be disproportionate to the benefits. Nonetheless, it will be the duty of the Secretary of State to ensure that targets set are met, but there will be reporting duties to Parliament which allow for an explanation to be given as to a target which hasn't been met and the steps which will then be taken to ensure it is achieved as soon as reasonably practicable. So that seems all quite aspirational. In terms of environmental improvement plans, they must be prepared by the Secretary of State, again for at least a 15-year period, setting out the steps the government intends to take to improve the natural environment over that period. And there'll be annual reports on the implementation of the plan and whether there have been any improvements. And it will also have to be reviewed 5-yearly. Environmental monitoring means the Secretary of State will have to make arrangements to obtain data about the natural environment in order to monitor whether it's improving with the current environmental improvement plan and also the progress being made towards meeting the environmental targets set. The policy statement on environmental principles must explain how they should be interpreted and proportionately applied by ministers when making policy. And it may also explain how ministers should take into account other considerations relevant to their policy when interpreting and applying the environmental principles. So what are the principles? There are 5 of them. 1, that environmental protection should be integrated into the making of policies. 2, the principle of preventative action to avert environmental damage. 3, the precautionary principle in relation to the environment. 4, that environmental damage should as a priority be rectified at source. And 5, the polluter pays principle. And the policy statement will be laid before Parliament. Ministers must then have due regard to the statement currently in effect, but that doesn't apply to policy relating to the armed forces, defence or national security, policy on taxation, spending or the allocation of resources within government, or to Wales, the country. Statements about bills containing new environmental law, when the minister introduces such a bill, they will have to make a statement that the bill will not have the effect of reducing the level of environmental protection provided for by any existing environmental law. And the Secretary of State must also report every 2 years on developments in international environmental protection legislation which appear to her to be significant. Moving on to the Office for Environmental Protection, which will be established and known as the OEP. Its principal objective will be to contribute to environmental protection and the improvement of the natural environment. And it must act objectively and impartially and have regard to the need to act proportionately and transparently. And the OEP must prepare a strategy, again to be laid before Parliament, setting out how it intends to exercise its functions and act in those ways I've just mentioned. It must also contain an enforcement policy, setting out how the OEP will determine whether failures to comply with environmental law are serious for the purposes of its investigations information notices, decision notices, and environmental or judicial review, which I'll come on to, and also how it will determine whether the damage to the natural environment or human health is serious. This is the word that comes up a lot in the bill, for the purposes of the judicial review provision. Also other matters such as how it intends to prioritise cases, and that will probably be those relating to ongoing or recurrent conduct that may cause serious damage to the natural environment or human health, or which may raise a point of environmental law of general public importance. There's a duty for a person with functions of a public nature to cooperate with the OEP and give it reasonable assistance in connection with the exercise of its functions, but that excludes, amongst other things, the courts and tribunals. The OEP must monitor and report on environmental improvement plans and targets, and on the implementation of environmental law, apart from matters which are within the remit of the Committee on Climate Change. And it will also advise ministers about proposed changes to environmental law or other matters relating to the natural environment. And that advice will be published and could also be laid before Parliament. I'd like to focus though on the OEP's enforcement functions. We find these in sections 30 to 40 of the bill, or actually 31 to 40. That 30 says that these provisions are about the functions of the OEP in relation to failures by public authorities to comply with environmental law. So what do we mean then by a failure to comply with environmental law? This would mean unlawfully failing to take proper account of environmental law when exercising its functions, and or unlawfully exercising or failing to exercise any function it has under environmental law. And I find it interesting the word unlawfully is used. How would that be ascertained and when? Who determines it? Does it have to have been determined first? It may be very obvious, but it may just be a slight implicity in the drafting. Anyone can make a complaint to the OEP if they believe a public authority has failed to comply with environmental law, and that will be under the procedure which it will be the duty of the OEP to prepare and publish. But the person making the complaint will have to first exhaust the public authority's internal complaints procedure if one exists. There will be a time limit of 1 year from the alleged failure, or 3 months from exhaustion of that internal procedure if it exists. So where a complaint is made, the OEP can carry out an investigation if it thinks that a failure to comply with environmental law was serious, or where it's got information which in its view indicates that. If the OEP won't take any further steps about the alleged failure and hasn't applied for environmental or judicial review, it has to prepare a report to the public authority about whether there was a failure to comply and with any recommendations it would like to give. But where the OEP has reasonable grounds for suspecting the authorities failed to comply with environmental law, and that if it has, it will be serious, it could give an information notice to the authority describing the failure and asking for a response, which will be within 2 months or such at later specified date. And where the OEP is satisfied on the balance of probabilities that there has been a failure to comply, then it can give the public authority a decision notice, setting out the steps required to remedy, mitigate, or prevent a reoccurrence. And again, that will require a response within 2 months or a specified later date. So let's look at environmental review and judicial review. First, environmental review. So this is where the OEP has given a public authority a decision notice, and only if it's satisfied on the balance of probabilities that the authority has failed to comply and that it is serious. It will be a review of the authority's alleged conduct. Now, the application can't be made before the earlier of the period within which the authority must respond to the notice, and the date the OEP receives that response, or before the expiry of any time limit which applies to the commencement of judicial review or similar proceedings for questioning the alleged conduct. This fascinates me because it's a judicial review first provision, whereas it's a cardinal principle of judicial review that it's a remedy of last resort. So on the one hand, this looks like some sort of learning exercise, and one which may or may not be necessary after letting whoever has sufficient interest to do so bring the JR, or perhaps waiting for the benefit of the outcome of that JR, noting also that provisions ousting challenge won't apply to environmental review, except that it doesn't seem to contemplate that an environmental review would still proceed if there was a JR, hence the reference to waiting for the expiry of the JR period. Now, I'm not sure how the OEP will monitor whether judicial review or other proceedings have been brought. The requirement, however, is simply to wait until the expiry of the JR or other time limit, and that's in any case in the alternative to the time when the response to the decision notice must be received, or in fact is received. In any case, what would the court do? It determines whether the authority has failed to comply with environmental law by applying the usual judicial review principles, and then it must make a statement of non-compliance if there's been a failure. But crucially, that won't affect the validity of the conduct in question, but it's also provided that where the statement is made, the court can grant any remedy that it could do on judicial review, other than damages, but only if there won't be substantial hardship to or substantial prejudice to the rights of any other person, or be detrimental to good administration. So in speaking of any remedy, that suggests there could be a quashing order, but how does that fit with the statement of non-compliance not affecting the validity of the conduct? And what were we meant by detrimental to good administration, and how could or should that override the failure that the court will have found to comply with environmental law? Finally, when considering whether to grant a remedy, the court must, but subject to all that, apply the usual judicial review principles. So does that mean that discretion will come into play? What's the scope for these principles in this context? Presumably there'll be some sort of mandatory order, given that the court would be dealing with a failure, but it could also be that a particular act constitutes a failure. So again, can the court quash? I think it's very unclear personally. When a statement of non-compliance is made, the authority has to publish the steps it intends to take. Again, that tends to suggest that there won't be any quashing, and is that even compatible with a mandatory order? On to a judicial review. This is a judicial review brought by the OEP itself. And the difference in electing between this and environmental review is that in addition to a serious failure to comply, the urgency condition is met as defined there. And there's a slight typo, I do apologise. I've said the urgency condition is that making an application under subsection, so it should be subsection 1 of what's currently clause 38. So this is, the idea is that the OEP would not use the information notice, decision notice and environmental review route and just go straight to JR. And notice that the relevant parts of section 31 of the Senior Courts Act specifically won't apply, hence therefore seem to apply in relation to environmental review by contrast. There's a similar requirement for the public authority to publish a statement with its intended steps in the judicial review route. Also, there's a provision for the OEP to intervene in other judicial review or statutory review proceedings going on, where it considers there's a serious failure to comply with environmental law. Just a note on the urgency condition and the amendments which have been made to establish that. It's been pointed out by Greener UK that in the previous draft of the bill, the OEP could apply for judicial review only if the OEP considered it necessary to prevent or mitigate serious damage to the environment or human health. But now that the OEP's discretion has been removed and replaced by an objective test of whether an application is necessary, that could make the judicial review easier to challenge, as well as lead to satellite litigation requiring the court to resolve whether this urgency test is met. I think that's a fair point. Another point which has been made is in relation to the forum for environmental review, which is obviously now going to be in the High Court rather than the upper tribunal. And the concern is that that represents a U-turn on the previous justification for placing the environmental review mechanism within the upper tribunal, namely that it would facilitate greater use of specialist environmental expertise. It's therefore thought that the environmental review mechanism has already been critically weakened, resulting in a narrower review. So there's some food for thought and a couple of points at the end there just to note. So thank you very much for listening to my talk. I'll pass on to James Maurici QC. Thank you.
Hello. So I'm, as usual, for the Planning High Courts Challenges conference, I'm covering practice and procedure. This year, I want to look at a mix of topics: alternative remedies, time limits, one case on standing, some stuff on discontinuance and withdrawing of planning judicial review and related claims. A little side note on listing in the planning court. The usual material, quite a lot on costs as usual, some cases on relief, and then a handful of other things. It's quite a lot to get through in my time, but we'll see how we go. So this year, 2 cases on alternative remedies in relation to planning, judicial review and statutory review. QM, the facts are a little bit involved, but the claimant got a planning permission for a proposed residential development subject to some pre-commencement conditions on remediation because there was a contaminated land issue. And subsequently, the claimant built 2 dwellings on the site and sold one of them to a couple. The couple then commenced civil action against the claimant, contending that they'd failed to discharge the remediation work condition, which meant that the property they purchased from the claimant couldn't be resold. So the claimant applied for a CLUID in order to try and deal with this issue. And in respect of that CLUID, the planning authority failed to determine it within time. So an appeal was lodged against non-determination, and that appeal was pending before PINS, awaiting determination, when the claimant submitted a second application for a certificate. This time, the council issued it, but with an informative that the remediation work condition had not been fully discharged. And the claimant tried to judicially review that second decision, so the decision to issue the certificate with the indication on it that this hadn't been discharged. So the claimant argued that although they had this appeal pending before PINS on the first CLUID, nonetheless, that wouldn't provide them with an alternative remedy that was satisfactory, and that JR should be allowed for 2 reasons. One, there were exceptional circumstances because it was only the JR that could determine definitively whether the informative had a lawful basis. And secondly, because of the civil action that had been commenced by the couple, they said that it was inappropriate and wrong and not right that the court, non-planning court, should have to deal with these issues, and it was better that the planning court deal with the legal issues that underlay all of these disputes through a judicial review. Now, Mr. Justice Dove rejected that. He said the claimants clearly had alternative remedy in the form of the appeal, and there were no exceptional circumstances to justify this matter being considered by a judicial review. And really 2 points. I mean, first of all, the judge obviously took the point that there wasn't actually an ability to appeal the decision to issue the CLUID with an informative because you're only able to appeal where it's refused in full or in part, not where it's granted but with an informative. But there was the earlier Cluid and the non-determination, and that had given a full right of appeal, which had been exercised, and the decision was pending before PINS. And obviously that decision would be a full determination on the merits. It was clearly an alternative remedy, and it was one that would be determined by PINS specialist inspectors who were used to dealing with enforcement issues and certificate applications. And the court emphasised that the framework of the legislation clearly was that you should go by an appeal, and that only after those appeals was the court's supervisory jurisdiction to be brought into play, and that there was no justification in this case for bypassing the mechanisms in the statute in order to allow this matter to be determined by JR. And in relation to that secondary point about it not being appropriate for these issues to potentially have to be resolved by a court in the context of the civil dispute that was ongoing, but by the couple who bought the property, the court said there was actually no reason why the court in civil proceedings couldn't and shouldn't determine that issue if it had to, and therefore no JR. So that's the first case. The second case, TMP, the developer was refused a prior approval to change an office building into residential property based on the interpretation of the authorities, local authorities' direction under Article 4 of the General Permitted Development Order. And the developer sought, somewhat strangely, by CPR 8 proceedings to challenge that refusal. And the court held no, the interpretation of that direction was quintessentially an issue of public law, not for Part 8 proceedings, but in any event, it should have been challenged through an appeal to PINS, not by coming through Part 8 proceedings. Certainly an odd case, that one. But there are two cases on alternative remedies. One case on time limits this year, South Derbyshire. Inspector's decision was the 9th of October, so a 6-week period for challenge under Section 288 expired on the 20th of November. The claim, including the application for permission, was filed and issued at court on the 15th, so within time, and posted to GLD on the 19th. But the local authority had relied on the address for service listed in the White Book, but GLD had moved offices, so that, unfortunately, they didn't get the claim until the 21st, so after the 6-week period. Now, a preliminary issue was raised that the application was not made within 6 weeks, as required by Section 288. Now, of course, I think as many of you all know, previous case law supported the view that the application is made when you issue it in court, and that serving is something separate and different from the making of the application, and which is governed not by the Act and its strict 6-week time limit, but by the CPR, which allows for extensions of time. But the argument was whether the Court of Appeal's decision in Croke in 2019 had changed this analysis. Well, the court said, no, it hadn't. Service is not part of making the application. It is part of the civil procedure rules. There is a power under the CPR to extend time, and Croke did not affect that analysis. But they did go on to say that in terms of non-compliance with the service rules, so if you fail to serve in time, as in fact, of course, had happened here, if the court's considering that kind of a failure, first of all, you should bear in mind these rules are in mandatory terms. Secondly, they are very much intended to give certainty within 6 weeks to people to know whether a claim's been made. So generally, you should expect service to be done properly and on time. But here, it was held the local authority had made at least a reasonable attempt to serve because they'd relied on the address in the White Book. And moreover, and perhaps more importantly, that the short delay in service had caused no prejudice. I turn then to standing. Airborough is a case which obviously has had a lot of attention this year. The quashing, well, not the quashing as it turns out, but the finding to be unlawful of the Greenbelt policies in the Leeds development plan. But in an earlier piece of sort of satellite litigation, the question arose whether the Airborough Neighbourhood Development Forum had the capacity to bring a challenge under Section 113 to the adoption of the site allocation plan. The forum was designated as a neighbourhood forum under the 1990 Act, Section 61F, with objectives that included, of course, the good planning of the neighbourhood. The designation had expired and its renewal was remaining pending at the time. The argument was not a person aggrieved under Section 113. There's a really thorough review by the judge of the case law on the standing of unincorporated associations in judicial review. In many of those, there appears to be no more than an assumption that you could be the claimant. There was also consideration of case law that had looked at this issue in the context of statutory review, the Williams case, which suggested that such an association could bring a statutory review. The judge agreed with that, held they did have standing to bring the claim, and relied on not just the thorough analysis of the case law, but the wider policy context, which suggested that the court should be more flexible to standing issues, particularly in planning environmental cases where the impact might fall on a group. Then discontinuance, there's really two cases I need to talk about here. One's Westminster. So these were two Section 288 claims brought by a local planning authority as claimant, and the substantive hearing was down for the 5th of March in front of Mr. Justice Holgate. Now, on the 12th of February, the claimant sent a draft consent order to the Secretary of State with a view to settlement, but not dealing with the Secretary of State's costs. The court wasn't notified of the intention to settle until the 26th of February. And the court then directed that there needed to be filed a full explanation of why this was being settled so late, why extensions of time had not been applied for various directions that were leading to the hearing. The claimant filed a consent order, but didn't, which actually provided for discontinuance of both claims and the vacation of the hearing date, but didn't offer any explanation of the procedural failure. And so the parties were pulled into court by Mr. Justice Holgate to explain the late settlement. And for those of you who've been involved in cases which have settled late in the planning court, this is perhaps not an uncommon experience, although it doesn't always lead to a judgment as it did here. So Mr. Justice Holgate was very unhappy about the delay in notification of the court about the prospect of settlement, and reiterated that parties really are under a duty to inform the court as soon as they become aware that a case may settle, because of the impact that settling cases late has on the ability of the court to deal with its caseload. Settlements, it said, which occurred at a late stage for no good reason, undermine the efficient running of the court process. And the judge drew attention to what's said in the Judicial Review Guide about good practice for dealing with a situation like this. I won't dwell on this bit, but the court also emphasised that when one is seeking a consent order, the requirement for the draft legal statement of the reasons for the making of the consent order does require careful consideration and drafting, not least of all because it may have consequences going beyond the case and the parties and give rise to issues about issue estoppel and abuse of process. And therefore, there really is a need to focus on the statement that comes with any consent order. The judge also said the fact that parties are discussing the terms of any draft order was not a good excuse for not telling the court, and that sanctions could well follow, including costs, to mark disapproval of the court if these things happened. The other thing the court dealt with was that the fact that the parties, because they knew the case was going to settle, they themselves agreed to effectively vary all the directions the court had given about trial bundles and skeletons to push them back later, and they did that by agreement. And the judge recognised that the CPR did allow this, but effectively strongly deprecated parties doing that because it would be contrary to the party's obligation to assist the court to push back deadlines by agreement to very late before a hearing. And any agreed extensions should not imperil future hearing dates or otherwise disrupt the conduct of litigation. And then one other thing just on discontinuance and costs. If you're going to end your proceedings not by a consent order that withdraws the claim and perhaps makes provision for argument on paper about costs as per M and Croydon, if you are going to instead go for discontinuance, which is a unilateral act, of course, by the claimant, just remember that if you do that, you are automatically, by the rules, saddled with paying the costs of the other parties as of the date of discontinuance backwards. And the Khan case, which is not a planning case, looked at how you can upset that presumption that costs will follow effectively be forced to be paid by the party who discontinues. And the court emphasised very strongly that there are going to have to be very good reasons for departing from that rule. And for example, the fact that you show as a claimant that you were actually going to win is irrelevant. Relevant in an M and Croydon case, but not relevant when you've discontinued because of the presumption in the rules. So just a short aside on listing in the planning court. Some of you may have seen this on the 23rd of September. There was a reminder from the planning court to PIBA members about fixing dates in the planning court, with Mr. Justice Holgate urging barristers and their clerks to be as flexible as possible when fixing dates, and that every effort should be made to accommodate dates that have been suggested by the listing staff. And I know there have been quite a few issues over the course of the last few months about getting cases listed, and that's what we've got from the planning liaison judge in terms of what the requirements are. So I'll turn to costs. 3 Aarhus cases this year: Kent, Bertoncini, and Abbots Kerswell Parish Council. So Kent, the interested party in this case, but not ultimately the defendant, challenged the entitlement of the claimant to Aarhus cost protection. And following a hearing, the court held that it was in fact an Aarhus Convention claim. Now, the defendant had in their summary grounds disputed that the claim was an Aarhus claim, but then adopted a neutral stance ultimately. The interested party, though, ploughed on with the point and lost following the hearing. The claimant sought costs of that hearing against the interested party, and the court held, first of all, that it had jurisdiction to award costs against an interested party in those circumstances, notwithstanding that CPR 45.3 referred only to a defendant, and it followed the Court of Appeals decision in CPRE in this regard as to how one is to read references to defendant in the Aarhus rules. You read them as incorporating interested parties. Secondly, the starting point is that if you contest whether something is an Aarhus Convention claim and you fail to persuade the court that it is not an Aarhus Convention claim, then you would normally have to pay the claimant's costs. And then, I mean, probably the most extraordinary thing in the decision, that the claimant actually obtained 24,000 plus VAT costs for that hearing. I'm not quite sure how that is compatible with Aarhus costs, but apparently it was an unusual case which required a lot of research and preparation. Then Bertoncini, on a paper refusal of permission, the defendant argued that the cap, and so the claimant's overall liability, should be increased from 5,000 to 10,000, whereas the interested party said it should be increased to 20,000. And on the papers, the judge did increase the cap to 20,000 and ordered the claimant to pay nearly £15,000, of which 10,000 were to be paid to the interested party. So the claimant renewed their permission application to an oral hearing, and then a point of jurisdiction arose, namely whether the interested party has standing to apply for a variation of an Aarhus Convention cost cap, given that there's no express effect provision for that in the rules. But again, same as Kent, same as CPRE, the judge held that the interested party does have that standing, and effectively the interested party, you read in interested party when you see defendant in the Aarhus cost rules. The cap was maintained at 20, and the claimant was ordered to pay quite substantial costs. And then Abbots Kerswell Parish Council, I just mentioned this, there's currently apparently an ongoing controversy as to whether the £35,000 Aarhus cap is inclusive or exclusive of VAT. In this case, Mr. Justice Dove, in an extemporary judgment, said the cap was exclusive of VAT, following an approach taken on the earlier version of the rules by Rabinder Singh QC, as he then was in Olley back in 2011. I understood the Secretary of State was considering whether to appeal that decision. I don't know whether it has been. And I understand there's at least one other case in the pipeline that also raises this same issue. And then one other case on costs, this time in relation to settlement and interested parties. A bit of a procedurally odd one, this one. So there was a judicial review by a claimant of a planning permission granted to their neighbour, who are referred to as N. Shortly before the deadline for acknowledgement of service, the council said it would consent. And so neither the council nor N as an interested party filed an acknowledgement of service, and a consent order was in fact under discussion. But then, perhaps a bit surprisingly, out of the blue, the court, without any acknowledgement of service, refused permission. The claimant renewed, and at this point, the interested party, no doubt invigorated by the refusal by the judge, decided to defend the proceedings and made an application to file an acknowledgement out of time. An oral hearing permission was granted, and indeed the claimant was given leave to amend their claim. And at that point, a consent order was agreed with costs to be dealt with in writing. And on costs, the judge said that the local planning authority had to pay the costs up until the 5th, but then N, the neighbour as an interested party, once they sort of took over the mantle of defending the claim, they had to pay the costs thereafter. The neighbour, the interested party, didn't like that. They appealed, but the Court of Appeal held that the court obviously has a power to do this on the papers. It has a wide discretion on costs, which it would rarely intervene on. And here, the court was right to have taken the view that the interested party had taken on the burden of defending the claim, and therefore they had to pay all the costs from the date they did that, even though some of those costs were not caused by its actions, but by the action of the defendant. And that was said to be justified by broad justice. So relief, just a couple of things on relief. I mean, first of all, Airborough, where the court found a number of errors in the process leading to the adoption of the lead site allocation plan. I think I won't go into the detail, but I think what makes it interesting is that because section 113 was amended to give more flexibility on how one deals with a successful challenge to a development plan, the court had a wide range of powers available to it and didn't find it necessary to quash the plan back to the beginning, but rather send it back to the point in the process where things had gone wrong. And then I guess I have to mention Plan B Earth, where obviously the court found a failure to have regard to the Paris Agreement. Clearly that's under appeal. We'll see whether any of this survives in due course. I know what my own view is on that, but I probably shouldn't go into it. But ultimately, despite that error, the court declined to quash, making a declaration instead in relation to suspending the effect of the MPS pending a review to be undertaken by the Secretary of State. But again, I think showing the flexibility of the court not to have to quash documents that are found to be unlawful, but it is on a normal judicial review, but finding other ways to deal with those errors. And then finally, there's a couple of other issues that I just want to pick up on. One is the issue about setting aside of orders on the papers. So for orders other than permission, which are made without a hearing, and where all of the parties have not explicitly confirmed their consent to the matter being dealt with without an oral hearing, in those cases, you treat the order that's made on the papers as if it was an order made on the court's own initiative, even if the applicant, the party seeking the order, had asked for it to be a paper decision. It's treated as if it was an order made by the court's own motion, not an order that's been made by all parties having agreed to it, because everyone has to explicitly agree that it's a paper decision. Now, if you don't like such an order, you don't have to appeal. You can apply to set it aside under CPR Rule 3.35. And there's some case law that explains this. It's actually ridiculously complex to get to that point, but there's two cases that will help you get there. But the issue that had not been determined, and which came up in the Kuznetsov case, was what test does a judge apply when he's asked to set aside an order made on the papers by another judge? What test do you apply? And Mr. Justice Mostyn held that the court should give due weight to the decision of the judge who dealt with the matter without a hearing, and should be able to identify a good reason for disagreeing with his or her decision. So that was the test, it was said, that was to be applied. Not entirely sure myself that that actually fits with the fact that the jurisdiction on applications to set aside orders under this relevant part of the CPR is actually by way of a rehearing, not a review, but that is what Kuznetsov decided. And then finally, amending grounds, just pick up on this keep Bourne End Green. Mr. Justice Holgate referred to what was an 11th hour application to amend the statement of facts and grounds, refused it because the new point was unarguable. But in any event, pointed out that it was effectively grossly late, made as it was effectively after skeletons. And contrast that with a more recent decision by Mr. Justice Lang in relation to a tall building in Birmingham, where the amendment was allowed, as it was not made at the last minute, but was made more than 7 days before the hearing. The lateness was also in part to do with the fact that the council had failed to load relevant documents onto its website. So that completes this year's roundup of practice and procedure. I'll hand over to Matthew.
James, thank you very much. There's some time now, I think, for some questions, about 10, 15 minutes to deal with those. Some questions have arisen. David, can I turn to you firstly? I have 2 questions. Perhaps you'd like to answer them in turn. The first is in relation to remote hearings. How do they resemble hearings in court? Could you give some comparison of that situation, please?
Well, put very briefly, Matthew, as I indicated at the end of my paper, although we're all sitting in our own rooms, probably unrobed, and with the kettle singing behind us, we are still in court, and the procedure will go very much as it goes in court, with any necessary adjustments to cope with the fact that we're dealing with it on the screen. So submissions in the normal order. It is a bit more difficult to have a discussion with your opponent to try and agree issues in dispute and say, well, you're not going to take that point, are you? Or can we agree this? You can't do that very easily because that has to be done by email. Communicating with the clients can be quite tricky. And what I've found an effective way of doing this via is WhatsApp on the phone. If you have WhatsApp, it's a much quicker version of communicating with your team, your solicitors, your lay clients, any experts. And I've found it's worked very well both for a public inquiry and for cases in court. So you can have a discussion offline without having to use your email and interfere with potentially with the signal or the use of the computer while you're in court. Other than that, and adjustments that you have to make because you're remote, they're pretty much the same. And as I've already indicated, contempt of court is as live as ever, whether we're remote or in court.
Sure. Thank you. The other question is the situation with regard to litigants in person. How does the court deal with that sort of situation?
Well, it's more that's one area where it can be potentially more difficult because getting litigants in person to operate through the court systems can make it even more difficult than when you have someone in front of you, and it's something that the Lord Chief Justice's report refers to. I've had several litigants in person in front of me while I was sitting. One of the advantages, oddly enough, to a remote hearing is, as is often the case, litigants in person don't always provide all the documents that they should or have sorted out their case. It's much easier to adjourn the hearing for, say, an hour and to say, go and find the documents and put them on the email than it is if you're in court and, of course, they haven't got them with them. So in one case, I actually adjourned a case with a litigant in person, I think 3 times, because I had to explain very clearly that certain documents hadn't been provided, and it took 3 goes to actually get them and to make sure that the defendants had them as well. Other than that, it requires a bit more patience on the part of those taking part, just in case the litigant in person is less technically equipped. But there can be advantages, as I've said, but it requires a degree of tolerance, I think, on the part of the court.
Yes, I see that. Thank you very much, David. That's been very helpful. That's answered the 2 questions. Can I turn to Kate next, please? There are a couple of questions that I want to deal with you. The first of which is what you think is the key concern in relation to the Environment Bill, insofar as it relates to High Court challenges. And if you were dealing with parties involved in challenges which had an environmental element, what sort of advice would you give them?
Okay, I think what concerns me the most is that the impression given is of a blurring of the procedural requirements, particularly between the environmental review and judicial review, as I was trying to explain, and it's not clear how they're going to sit together for the reasons I spoke about. And I think there's a lot left to be worked out, which isn't currently clear, and not just the details, but quite important matters of principle. In terms of what I would mention to people who will become involved in environmental challenges, certainly I think there's going to be a challenge to work out whether the OEP may be involved, or the scope for getting them to become involved, and in any event, again, how to dovetail the procedures.
Yes, thank you very much. That's very helpful. The second question that I have for you relates to the objective of improving the natural environment and what it applies to. Mm-hmm. The question really is whether it applies to infrastructure schemes like road schemes. Can you help on that? I
don't know if this is going to the biodiversity net gain policy. I mean, certainly national infrastructure projects which are covered by the 2008 Acts will be exempt from that policy, if that's where the question is going to.
That's very helpful, thank you. I imagine that is the position. The only other, I do have one other question which relates to the potential for some satellite litigation that might arise from the Act as and when it comes forward. Do you have any comment to make on that, the potential for any?
Yes, no, I mentioned one, I think, in relation to the objective test as to the urgency condition where the OEP might bring a judicial review. So I think certainly anywhere where you've got objective tests incorporated, and I think it's not so much satellite litigation, but I think there's a lot of room for discussing exactly which principles and which remedies are going to apply, because even though it says in terms all of the remedies in judicial review, I actually don't think it's clear, again, as I've tried to point out.
Yes, thank you. Thank you very much, Kate.
Thanks, Matt.
Can I turn to you, please? Some questions for you, if I may. The test in Porter and McGill, where do you think it stands in terms of the potential for bringing a claim? Do you think it's a test that is about right or too strict, or do you not have a view on that?
You'd get a shock if I said I didn't have a view, Matt.
I'd enjoy it very much if you did.
No, I think it's about right. I do think it's about right. I mean, the history of litigation on the subject has shown it's a pretty high threshold, and I think it probably must be right, because one mustn't forget there must be a public interest that those in decision-making positions are not subject to allegations of apparent bias which are without substance. I would say that it must be right that the gateway test is pretty significant to get such litigation off the ground. To obviously avoid it could be used tactically or inappropriately if the test was lessened. And I think, I mean, as in Westferry, it proved the test was right, and clearly the government lawyers felt it had been met. And yeah, I think it is about right.
But that said, I mean, do you think that it's fair to say that it's a reasonably difficult test to overcome if you're going to bring that sort of point in court, or one that you
absolutely, I do, and I think history again shows that the number of apparent bias successful challenges are small. I'm sure many fail the gateway test, and many also fail the substantive test once there is actual litigation. So no, I think it is right.
Good, thank you very much, Sasha. Thank you for that. James, can I turn to you then finally? There are two questions that I'd like to ask you. The first relates to the CPRE against Secretary of State case on the costs of interested parties of the acknowledgement of service. Is that going to the Supreme Court? Is that right? And if it is,
yep.
When does it go?
Yeah, that's going to the Supreme Court in January 2021, and I mean, it does directly bring into question whether the long-established Leach, Mount Cook, Luton rule that more than one party gets their cost of the acknowledgement of service prima facie anyway if permission's refused, should be the rule, or whether Bolton should apply at that stage. And there were more issues in the Court of Appeal, but essentially that's the only issue that's going to the Supreme Court, and that's being heard in January.
Yes, you want to give any assessment of the prospects?
Well, I better not, because I'm now appearing for the Secretary of State, so I probably better not.
Go on then.
I think I best not.
All right, well, I'll go on then swiftly to the next question. It concerns the report in Lawtel today of a case dealing with the setting aside of the refusal of permission to appeal to the Court of Appeal, particularly in planning cases. Can you help on that? And
yeah, it's Wingfield, which I think was reported on Lawtel today. I think it was last week the judgment came out, but I mean, perhaps not surprisingly, the Court of Appeal lays down the fact that you are going to have to meet a very high hurdle indeed to persuade the court to set aside a refusal of permission to appeal in a planning case, because obviously the test is already a high one, because of the importance of certainty at the end of legal proceedings. But in planning, the court emphasised that's even more so. I mean, this was a pretty extraordinary one, because this was the second time that this particular person had applied to set aside a refusal of permission to appeal. And the second one was on the same grounds as the first one, as I understand it. And not surprisingly, it failed. And the court was very strict about this not being something that should be regularly employed as a way in which trying to reopen cases that have been refused permission by the Court of Appeal.
well, I suppose that must be really the right test, mustn't it? I mean, it must be the right approach.
It has to be, and I mean, I think there are some earlier cases, including in planning, that established a very similar test, and where the court gave pretty firm warnings that people shouldn't do it. Obviously, the decision was made here that that such an application should be made twice, but not surprisingly, it got knocked back. I mean, effectively, what the court was saying was you need something pretty close to either fraud or some really very, very hugely serious error that vitiated the whole decision, and was absolutely obvious to even get off the ground for this.
Yeah, good. Thank you very much. I mean, that's very helpful. Just check, I don't think we have any more questions that need to be answered. So that's everything covered, I think. I want to thank all of the speakers for their contributions today. And I want to thank, of course, all the people who joined the seminar for joining. We hope, of course, you enjoyed the presentation. The slides, I should say, will be circulated by email. There are, of course, future seminars, which you can find on the Chambers website, and watch out for the email invites for those in the future. Well, thank you once again. I hope you've enjoyed it. And the seminar, I can say now, is closed.